Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
All right, so Phil, I've got a few topics I want to cover today on lawyer on the clock, and just trying to get my notes in front of me here. So the first one I want to talk about, I'm just going to mention it real quickly. There's a lot in the news these days about no tax on tips. The big story in Congress right now is that the Republican lawmakers in the House are working on a large-scale tax bill that would extend the 2017 tax cuts and, among other things, end taxes on tips and overtime pay. While those discussions have been playing themselves out, a senator moved to pass what's called a standalone no tax on tips bill through a process that requires unanimous consent, meaning no floor opposition, and it passed. 100 senators voted for this no tax on tips bill. And this bipartisan support is really significant. Even though the bill still has to clear some hurdles, it represents an important step here, and it might end up getting approved as part of President Trump's one big beautiful tax bill that the GOP is currently fighting over. But if passed in both chambers, the act then would need to be signed by President Trump, and that, of course, would be expected to happen since he campaigned on the promise of no tax on tips to service industry workers last fall. Just a couple of quick notes. The deduction would be capped at $25,000 per year. It would apply only to income tax, meaning workers would continue paying payroll tax on tips. And to claim the deduction, an individual's compensation must be less than $160,000 in 2025, a cutoff that would be indexed to inflation. So something to keep our eyes on. I do think that there is a lot of momentum and a lot of bipartisan support for that hospitality, restaurant, retail sector. And for all those who didn't like my comments last week regarding the Missouri paid sick leave, hopefully you'll like my comments on this one, because I think this is going to happen for you. Next,
it definitely sounds like it. When's the last time you can remember something getting 100% support?
Seriously.
That's a new day.
It is.
Very good.
It is. All right. So the next one I want to chat about real quickly is the Republican lawmakers are also tossing around some proposals on Capitol Hill right now, which would make it much easier to classify workers as independent contractors. You know, this is one of those pendulum issues that from administration to administration, that pendulum has really swung wildly in recent years on who can be an independent contractor and who can't be an independent contractor. Republicans have advanced a bill called the Modern Worker Empowerment Act, which would amend the Fair Labor Standards Act and the National Labor Relations Act in two ways. It would deem a worker an independent contractor if that person engages if the person engaging them doesn't exercise significant control over their work, and the individual has the ability to use discretion and judgment in the performance of their job. Now, of course, this is a really big deal because on top of not being eligible for overtime pay, independent contractors are not entitled to certain other legal protections and benefits afforded to employees, such as minimum wage and paid and unpaid sick time. So just another thing to really keep our eyes on out there.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.